This is Mike Franklin. I'm the legal representative for 140 East 1st Street in Corning, New York. And the property is in Steuben County. And we're going to have, this is an addendum to the Small Claims Assessment Review SCAR petition. I'm a licensed New York State real estate broker. I have 25 years of experience as to what properties list for, sell for, assess for, and appraise for. I have 13 years experience participating in Board of Assessment Review and SCAR cases as an advocate, and I, literally hundreds of cases. And I have 4 years experience as a Small Claims Assessment Review hearing officer in 6 counties. And today I'm here representing this property, and I'm going to review this addendum with you. Before I get into the text of the addendum, I'm just going to say briefly what transpired here. The taxpayer had transferred for employment purposes from California and had 3 weeks to purchase a house for his family. And so he didn't have time to analyze the local market in a standard way. And therefore, I believe that the purchase price was not an arm's length transaction. But yet the assessor, despite not having done a revaluation, used the purchase price. She arbitrarily raised the assessment $100,000 even, and applied the equalization rate on top of that. And I find that to be arbitrary and capricious. There have been no improvements to the property. There was no revaluation done to the other properties to bring them in line with this property or this property in line with those properties. Therefore, the assessment is illegal. And it needs to be reverted back to the previous assessment, adjusted for the new 2025 equalization. So let me get into the SCAR petition itself. And by the way, the assessor had a connection to this property. And as you'll see later, as I review this addendum, you'll see that this house is on the front page of the assessor's webpage. And this property owner purchased this property from a well-known citizen of Corning, who is a well-known historian and apparently friends with this assessor. So when she did the revaluation, she didn't do to him what she did to the stranger, new person in town. And I'm going to suggest that was some sort of favoritism, some sort of crony, base. And I think it's improper. She had no legal justification to change this assessment from $280,000, not one penny. And if she does, we'd like to hear about it in this hearing. So let's get into the addendum. The property was selectively assessed in violation of RPTL 305 and the Equal Protection Clause of both the United States and New York State constitutions. People have a right to be assessed fairly, and that's not what's going on here. The property was assessed in 2024 for $280,000. It was raised to $330,000 in 2025 illegally. Since the property was not improved and there was no citywide revaluation, the assessor should have simply applied the equalization change. Instead, she raised it arbitrarily, applying a recent non-arm's length sale in violation of RPTL. The assessor has no legal justification to change this assessment, not even a penny. We request the following adjustments: assess $280, fair market value $282,828. Okay, and I will concede the property sold for $410,000 on November 22, 2024, which, by the way, is past the valuation date, and the sale should not have been used for that reason as well. But it shouldn't have been used at all because there was no revaluation done. So there's two reasons why this property should not, the assessment should not have changed. The valuation date is July 1st, 2024, and it sold 11/22/2024, which is 4 months past the valuation date. I provided an opinion of counsel. An assessor may not selectively reassess properties, such as reassessing only those properties which recently have been conveyed or improved, which is exactly what happened here. However, an assessor is not precluded from revaluing any real property unless that assessor reassesses all real property, which was not done. Rather, an assessor may change the assessment of a particular property, class of property, or neighborhood. But if challenged, he or she must be prepared to show how any change brings such assessment into line with those of other properties whose assessments go unchanged. And I'm going to challenge her to do that, but she can't because she didn't. It's a clear, illegal assessment. Okay. We challenge the assessor to document a rational basis for the increase from 280 to 380, subsequently reduced to 335, also arbitrarily at bar. They just split the baby. They did no calculation, no quantitative analysis. They winged it, just like she did. Just a round 100,000. Let's add 100,000 to it. She knew better than to just pin it at 410 because that would be too obvious. Okay, rational basis examples would be current year revaluation improvements to property. There were none. Assessors can rebut claims by showing a rational, non-discriminatory basis for the reassessment. Market value adjustments or improvements. I challenge her to do so, but she can't. Buyer was from California and got welcomed by a 38% assessment increase, with other properties received a 1% increase as a result of equalization, the very definition of welcome stranger. Whereas this property owner received a $100,000 arbitrary increase plus the 1% equalization increase. Property owners from California recently took a job in the area due to employment and family constraints. He had little time to familiarize himself with the local market in a way a local buyer would, which impacts whether the sale was in fact arm's length. He had 3 weeks to find a home for his family. His circumstance does not meet the definition of an arm's length transaction, as there is undue influence and pressure to make a purchase more quickly. The previous owner was assessed at $100,000 less after the revaluation. The person was a well-known and popular person named Tom Dimitrov. Tom had been an inductee to the local Hall of Fame. His house is pictured on the assessor's webpage. So here's a screenshot of the Corning assessor Barbara Roberts' webpage. She is quite apparently familiar with Tom Dimitrov. I think that's incontrovertible. I think it's a clear sign of cronyism. She took it easy on Tom. Or not. Okay, Tom is a well-known historian and apparently was favored by the assessor and condoned by the municipality in violation of RPTL. It is cut and dried crony fraud. But in any case, the assessor has no legal justification to change his assessment other than the equalization change. We ask the assessment be remanded to the revaluation figure, adjusted for the equalization change for 2025, like all other properties. That figure would be assessed $280,000. 99% equalization would bring it to $282,828 fair market value. The welcome stranger doctrine, also known as selective reassessment, refers to the practice in New York where a municipality reassesses properties value based solely on its recent sale price or improvements, while leaving comparable properties that have not been recently sold or improved unassessed. That's exactly what happened here. This practice has been challenged in court as violating the principles of uniformity and equality in taxation under New York's Real Property Tax Law 305 and the equal protection clauses of the U.S. and New York Constitution. Below is a summary of key case law in New York addressing the welcome stranger doctrine based on the relevant judicial decisions. And I have documented all these cases for the record in case this needs to go to Supreme Court. And you can read all these here. It's incontrovertible, and I think the assessor having Dimitrov's property, the subject property, on her webpage is a pretty good indication of what's going on here. But in any case, this case could not be more simple. She had no justification to change this assessment whatsoever, and it must be remanded to the previous assessment, which was $280,000, adjusted for the 2025 equalization. This is Mike Franklin, the legal representative for 140 East 1st Street, Corning, New York, Steuben County. Thank you.